Waikutep, Judy Wilson, Red Hummingbird. That's my traditional name. I'm from Sequetum, Ulu. My home community is Nisconnet, and I'm on the lands of the Squamish right now, though, in Whistler. So I'm appreciative to being on these unceded territories. And welcome to the circle today, Caring Society, We Can Do Better. And I will do a prayer to open up the meeting. And if Deb's here, she might want to share some words as well. So I'll just start this. Cooksjam, Tulkukbi Creator, we thank you, Creator, for this beautiful Mother Earth and our life source, the water. We also thank you for all of the creation, especially at this time where the leaves are changing color and the weather's cooling, and also the work of the harvesting and the feasting is happening across Turtle Island, where the people go back inside their homes or their lodges, and they storytell and they share with one another what they learned, and also most importantly, Creator, they bring their families together. So that's what we pray for all families, Creator, that their children can go home, their children can sleep in their own bed, their children can have their parents, their grandparents, their extended family, their aunties, their uncles, and the quality of life improves, Creator, which we all work towards for our children and our grandchildren, those yet to come. So we pray, Creator, that with the collectiveness, mind, body, and spirit of the ones on the call today, that we can enlighten ourselves, we can share our knowledge and concerns, and also find ways, Creator, we can put forward solutions to be able to make this a reality for an improved, better, we can do better lives for our children and our grandchildren, those yet to come. So we thank you for our sacred medicines, Creator. Many have harvested and prepared those medicines that help us in time of sickness, but also help us, Creator, when we need to smudge, cleanse, or connect, Creator, through our medicines. So we thank you for the tobacco and the sage and the sweetgrass and the juniper and the cedar, all the different medicines that you give us in a good way, that when we walk and harvest our medicines, they're there for us. And we also thank you for the element of the fire that also is a cleansing way for us as well. So we thank you for that. And also Mother Earth, when we need to ground ourselves, we can just think of Mother Earth and it's grounding for us. And also the life source of the water. So we thank you for all of the sources that are elements and that we always need to keep in harmony and balance. And we pray for our knowledge keepers and our language keepers that they'll keep continuing sharing that with us so that we can continue it just as our ancestors did. So at this time, we thank you for our circle, and also we thank you for our ancestors, our guardians, and our helpers that help us each and every day. And we pray for them to be with us in this circle today as we have these discussions, and that we can, again, walk in a good path, Creator, that will help our children and our families in the best, utmost way possible. So we thank you for our grandparents and our grandfathers and our extended families. And we thank you for all those that walked before us, Creator, because they paved the way for us. And now we're the one that has to hold up that torch, that candle, Creator. So to continue to light the way for us. So Cooksjam, 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 Cooksjam. Thank you.
Thank you, Judy Wilson, for that opening prayer. So good morning, good afternoon, everyone. My name is Stephanie Wellman. I am the Reconciliation and Policy Coordinator at the Caring Society. Thank you so much for joining us today. We're really excited to have you. Today, I'll be your moderator, Master of Ceremonies, taking you through this webinar. So I am joining from unceded, unsurrendered Algonquin territory here in Ottawa, and just want to recognize and acknowledge where all of you are joining from coast to coast to coast. We have a really exciting webinar planned for you today, lots of information to share. We are going to hear from legal experts and technical experts on long-term reform of the First Nations Child and Family Services Program. And our theme for this webinar is We Can Do Better for First Nations Children. And what we mean by we, that means the collective we. Just like Judy said, you know, welcome to our circle. For Caring Society, the circle is open to everyone because we know that when we all work together, it benefits the kids the most. So today we're going to hear from Mary Teegee, Scott Smith, Sarah Clarke, and Dr. Cindy Blackstock. We also have a Q&A available for you for your participation. And we also have the chat. Encourage you guys to pop your questions in the Q&A box. I have some of my friends from the Caring Society also with us to help with questions. Hi, Brittany and Jennifer. Thanks for being with us. And we also have live French translation available. And just a reminder for any Q&As, just to note that we can't really discuss any personal or individual cases, whether it be Jordan's principal or child welfare. So just want to be mindful of that. So to jump right in, we're going to have Mary provide some welcoming remarks from the Caring Society and Our Children Our Way Society. I'll provide a little bit of background and context so we're all on the same page for this webinar. Then we're going to hear from Scott Smith, and then we'll hear from Sarah Clarke, and then we'll hear from Cindy, and then we'll hear a regional perspective from Mary, and then we'll jump into a live Q&A. So I will throw it over to Mary to provide some welcoming remarks.
Good morning, everybody. I'm Mary Teegee. I am from Takla Nation. My traditional name, my hereditary name is Mausham Gabu, which is White Wolf. I am Gixon Carrier. I am the chair of the Our Children Our Way Society. I am also the British Columbia representative on the Caring Society, and I represent British Columbia on the National Advisory Committee for Child and Family Service Long-Term Reform. I'm just so honored that you're all here today, and I think it's really is a testament to your commitment to do better for our children. And collectively, I know we can do that. This webinar, we're hoping that we provide you with as much information that you need to make a well-informed decision, because that's what our children and our families deserve. We have to put it in a context that this fight that we've had for justice for our children has been over 18 years. And so now this would be the final settlement for child and family service long-term reform, and that's very, very key. It's long-term reform. It's just not reform for 10 years. It has to be longer than that. And how we do that is getting the best minds together to consider how do we change the system so this never happens again. In fact, that's a challenge, and that's a charge, and that's an order from the Canadian Human Rights Tribunal to ensure that discrimination not only ends but never happens again. So this final settlement agreement, when we look at it and we see the big amount, 47 billion, that's just a projection. It's not something guaranteed that is right there right now. So we have to ensure with all of us on this webinar and across Canada that we make sure that when we're long gone, that discrimination won't occur at the hands of Canada again. And so I really look forward to this webinar. We look forward to your questions and your comments, and to be really, I think we have to remember that this fight over 18 years or longer than that, don't forget, there's been so many people before us, but this last legal battle, over 18 years that we've been doing this, that we can't drop the ball at the 1 yard line, that we're so close to getting a good agreement, but we have to do it collectively and put the best minds forward. And that's why the webinar, the intent of this is that we can do better, because we know we have so much information from the frontline workers, from our families, from the youth themselves that we've amassed over all these years. We need to ensure that the agreement is reflective of not only what they're saying, what they've said, and the research that we have, but also is reflective of the true spirit of our people. We cannot lose sight of the voices that are no longer here with us. Many of the elders and people that have advised us all these years are no longer with us, and so we must honor them by ensuring that what they envision, that we get as close to that as possible. I think when you know, the next few hours that we're together is to not only listen with your ears and your mind, but more importantly, listen with your heart and with your own spirit. And that's what we ask of you for the next couple hours. And I'm really thankful that you're here, and welcome all of you.
Thank you so much, Mary. So we're gonna dive right into some very quick background, just so everyone is up to speed on why we're here and some context setting. So to set the context of why we're here and the situation for First Nations children, research and evidence shows us that 72% of First Nations children in care are off reserve, while 18% of First Nations children in care are on reserve. And evidence shows us that First Nations agencies are, in fact, more likely to keep children in community. We also know that the needs of First Nations children and families is growing. And for us, we don't think First Nations children should be limited to Indian Act definitions for support, but that it should be defined by nations. And it's the same approach for Jordan's principle. So what is the CHRT case all about? This case is about stopping Canada's discrimination against First Nations children, youth and families now and forever in the First Nations Child and Family Services Program, as well as Jordan's principle. So how do we keep all these cases straight? So there is compensation, which is finished at the tribunal. It was approved by the tribunal, and it's now with the class action. There is also the Jordan's principle process. The CHRT still has jurisdiction over this, and it is a separate process from what we're talking about today for child welfare. And those negotiations have not yet started, but we anticipate that it's going to start soon. We have some more information on that. And then, of course, the other big component of this case is the First Nations Child and Family Services Program reform. And of course, the CHRT still has jurisdiction over this right now. And for some of the parties, it's the FSA that they're as a pathway to ending discrimination in this case. So how do we get there? There are 3 paths to ending Canada's discrimination and making sure it doesn't happen again. So it can be negotiation, it can be litigation, or it can be a combination of both. Negotiation, which is how the draft FSA was reached, is the result of negotiation. So negotiation requires agreement from Canada, whereas litigation does not. So a combination of negotiation and litigation could include consent orders on matters that Canada agrees to, and then going for contested hearings, say at the tribunal, on matters that they don't agree with. And we've seen this for a few years as Jordan's principle has been progressing at the tribunal as well as the child welfare program. So both of these processes, though, would require approval by the tribunal. And it's always important to keep in mind that the orders from the tribunal do not expire unless they're replaced by another order. So again, Jordan's principle is not part of the FSA that we're discussing today. It's a separate process. And as many of you know, we were at the tribunal last week for a non-compliance hearing on Jordan's principle. And it is where we heard that AFN in Canada do plan to negotiate a Jordan's principle final settlement agreement by March 31st, 2025. So I feel like that's really important context for you guys to be aware of. And that's because we think that the Jordan's principle process could, or this process could set a precedent for the Jordan's principle process. So as I previously mentioned, and Canada said this at the non-compliance hearing last week, that They will negotiate another FSA with the same parties. And also, you know, during the non-compliance hearing last week, we did hear that AFN opposed the relief being sought by BC Leadership Council and the Caring Society. So AFN was proposing short-term orders so that they could negotiate an FSA on Jordan's Principle. So we feel that there's two key steps to finalizing the human rights case. And we're gonna dive more into this, but it's that leadership has to approve the final settlement agreement. And then it goes to the tribunal for their review and approval. So those are the next really big two key steps. We have here leadership approval. It could also include amendment to the draft FSA. However, the process is not super clear to us on how that's going to take place. It's also important to note that the draft FSA is not complete. There's a few really critical pieces that are missing, the big one being the terms and conditions. For those that are fully immersed in ISK's programs, you know that terms and conditions is really where implementation happens. The FSA also mentions alternative dispute resolution enabling legislation, but we won't get to see that until after the tribunal approves the agreement and effectively ends their jurisdiction. And then there's also a few sections on capital and post-majority that are missing. And then a French version of the FSA wasn't made available to our French First Nations until about mid-August. So they were quite far behind in getting their analysis done of the FSA. So some important key votes for everyone to be aware of, or key dates. Because as I mentioned, leadership does have to approve the FSA. So NAN is having their vote on October 9th. Chiefs of Ontario is having their vote October 10th and 11th. And then AFN is having their Special Chiefs Assembly for a vote on October 16th and 18th. Really encourage you guys to get engaged and talk to your leadership about this. So now that you're equipped with all the background information, so we're all at the same starting point, I'm going to turn it over to Scott Smith to give us an introduction to the FSA, an overview, and some other information that you need to be aware of. So over to you, Scott.
Yeah, thank you very much, Stephanie. So my name is Scott Smith. I'm a partner at Berlis, and I practice in the area of environmental and Indigenous resource law. And initially, when I started using that term Indigenous resource law, it was really around major projects. But over the course of the last 8 to 10 years, working with Dr. Blackstock and Mary and others, I've come to know that our most important resource is our children and families. And I always like to give away the punchline of my talks before I start. And the short punchline here is we can and must do better in relation to the FSA. And there's lots of opportunities for us to do that. So today I'm going to walk you through 8 key points. Stephanie's covered much of the background and context for the FSA, so I'm going to skip over those slides. But the key message here is the work we're doing together is to ensure that the discrimination stops and never happens again. Unfortunately, the FSA as it's currently drafted is not up to that key fundamental principle. I'm going to talk a little bit about some of the provisions in the FSA that require AFN, COO, and NAN to promote it and to procure leadership's approval. I think it's very important that people have those provisions in mind as you're attending some of these information sessions that are being carried out across the country. I'm going to talk a little bit about international law and what international law has to say about the requirements to participate in open negotiations and for disclosure in these kinds of negotiations involving very serious violation of human rights that occurred and is ongoing and was the subject matter before the Canadian Human Rights Tribunal. Talk a little bit about the potential for ongoing discrimination based on the current draft of the FSA. You'll hear later from experts that the funding is not sufficient to end the discrimination, ensure it doesn't happen again. And unfortunately, the FSA really doesn't provide the mechanisms to address shortfalls and to prevent discrimination from reoccurring. I'm going to talk about the lack of decision-making role. My slides will focus on British Columbia just because that's where I live and reside and have spoken to the chiefs previously about. But those slides really apply everywhere outside of Ontario. And there really is no role for leaders in decision-making processes to implement the FSA after it's been signed. I'll talk a little bit about the dispute resolution mechanisms, talk about what the FSA has to say about C-92, self-government and treaties, and Indigenous people standing up their laws to apply to their own peoples. And then I'll end by looking ahead and providing a brief description of what's next. So just a bit of a disclaimer here. So I am doing this on a pro bono basis. I'm going to be providing legal information, not advice. That's not a substitute for folks getting their own legal advice from their respective legal counsels. So I'd like to skip in over the background and really get into what I think is a very key provision of the FSA and how that relates to ongoing information that's being disseminated around it. And I'd really like to draw your attention in particular to Section 379 of the FSA, which requires AFN, COO, and NAN to, quote, promote the FSA and make best efforts to, quote, procure your approval. This provision really requires folks that are representing those organizations to do what they can to procure your approval for it. And you'll see in a couple slides, that's actually very different from the requirements that have been set out in Chiefs of Assembly resolutions. Like they were supposed to bring back options to the chiefs informed by technical considerations. And instead they've brought back, I mean, people are calling this a draft. It's really an execution copy of the final settlement agreement. There is no room to make change and to incorporate your thoughts and considerations. And so I'd ask you to carefully weigh the information that you're receiving. And another sort of very key concerning element of the FSA is key information may not actually be reaching you. This is because AFN, COO, and NAN are under an obligation to keep all of the conversations, discussions, and communications about the agreement in principle and the final settlement agreement negotiations confidential. So you'll see in a second how that stands in stark contrast to the requirements of international law that, of course, have been incorporated into the United Nations Declaration on the Rights of Indigenous Peoples. So just to skip ahead to that issue, another key, this is a process consideration. I'm very concerned that legal standards from international law and human rights are being ignored in the negotiation process for the final settlement agreement and the process to promote it. So I'm just going to summarize. We've looked in this for the Caring Society, and at international law, victims of human rights violations have the right to reparation. And this includes being consulted about and actually participating in the development of measures to eliminate systemic discrimination. So the FSA is a critical measure that is supposed to be designed to eliminate the systemic discrimination in relation to the funding of child and family services on reserve across Canada. And I wanted to share this quote with you because I think it stands in stark contrast to what's happening. And this is a quote from international law. So, institutional reforms aimed at preventing a recurrence of violations should be developed, and I want you to focus on these words, through a process of broad public consultations, including the participation of victims and other sectors of civil society. And this really hasn't happened. The negotiations of the FSA were done on a private, secret, confidential basis. None of this information was being shared, and it still can't be shared with you, even in the information sessions that are being carried out. So, of course, those standards at international law were enshrined in the United Nations Declaration on the Rights of Indigenous Peoples, and in particular, the right of Indigenous peoples to be informed and consulted about matters through their own representative institutions, chosen in accordance with their own procedures. So Articles 18 and 19 of the Declaration really speak to the situation we're in, and I'm just going to focus in on Article 19 here, which says that states shall consult and cooperate in good faith with Indigenous peoples concerned through their own representative institutions. And I want to emphasize this, in order to obtain their free, prior, and informed consent before adopting and implementing legislative or administrative measures that may affect them. So again, the FSA is one of these administrative measures, has the potential to really seriously impact First Nations peoples across Canada. And what is required here, the legal standard, is free, prior, and I want to emphasize informed consent. And that would require the ongoing disclosure of information both during the negotiation of the FSA and in the process we're in now. And I can reassure you that hasn't happened. So there, in addition to the standards at international law that apply to serious human rights violations that have been enshrined in the Declaration, the honor of the Crown and Canada's fiduciary duties to First Nations are also at stake in relation to the final settlement agreement. From my review of the agreement, it appears to me that Canada has offloaded those duties under international law, as well as pursuant to the Declaration, the honor of the Crown and fiduciary obligations to AFN and others. So there'll be a lot of discussion in the coming days about AFN being a representative institution that was chosen by First Nations in accordance with your procedures. Now, even if those arguments are advanced, it's pretty clear to me that AFN has not followed the requirements the Chiefs and Assembly established in accordance with their procedures. And I'm going to walk you through two resolutions that I think speak very much to this issue. Before I get there, I wanted to make one quick point about the steps that were taken prior to AFN and the Caring Society jointly filing the complaint in 2007 before the Canadian Human Rights Tribunal. Those were brought before the Assembly of First Nations, Chiefs and Assembly, and the Chiefs and Assembly at that time in 2006 approved both the AFN and Caring Society to bring that forward. So despite this, and this is deeply troubling to me, the Caring Society was inexplicably excluded from the FSA negotiations. So arguably, the organization in Canada with the best technical understanding of what was happening here was excluded partway through the FSA negotiations. So I'm going to turn to a couple of slides here, and I'm going to just quickly walk everybody through two resolutions that have been passed that very much speak to what was required during the negotiations of the FSA and what would be required to bring it over the line and have it approved. The first resolution that I'd like to draw your attention to is AFN Resolution 40 that was passed in 2022. So you'll see there's a lot of red on this slide. This indicates non-compliance with key elements of that resolution. Simply put, it hasn't been complied with. And really, if we were giving it a grade, the grade would be an F, failure. So in the column on the left-hand side, we have the core elements of the resolution, and then the middle column deals with the status. So the first thing that the resolution required is no reduction in funding. You'll hear from experts later that the FSA funding is inadequate. Even more troubling, that funding is only being provided over a 10-year term. What happens on year 11? We don't know. It's also subject to appropriations, and we'll talk a little bit about that in a second. Next part of the resolution, the First Nations and Assembly must approve the final settlement agreement on long-term reform. We're unclear as to whether that's going to be complied with. There's some very loose language that's used in the FSA saying that it's contingent on the endorsement of First Nation leadership. There's been no direction provided as to what that actually means. A third element, Canada was to fund the First Nation National Advisory Committee to inform the FSA. That not only was that not done, the AFN stopped calling NAC meetings in February 2024, and there's been no input, from what I understand, from the NAC into the final settlement agreement. Next, Canada was to provide the chiefs with, and I want you to focus on this language, all available options and related supporting financial resources to ensure FPIC on long-term reform, rather than coming back to you with options for you to consider and key financial mechanisms. You've been provided with what I would call an execution copy of the final settlement agreement that's not subject to any change. Finally, the resolution requires that the FSA not inhibit the right to seek CHRT orders. The FSA is entirely non-compliant there as well. And I'm sure Dr. Blackstock will speak to this, but the FSA actually seeks to end the CHRT jurisdiction. So this was a resolution passed by the BC Assembly of First Nations in 2024. It also hasn't been complied with. So the first element of that resolution is that BC-AFN directed that AFN to ensure that First Nations title, rights, and sovereignty are acknowledged and upheld in any negotiations related to children and families. We'll get into this in a second. This has absolutely not been required or complied with. You'll see there are no decision-making roles for folks outside of AFN or Ontario set out in the FSA. Second, AFN was to share drafts of the FSA with the Caring Society, the NAC, regional experts, and meaningfully incorporate their recommendations for change. Meaningfully incorporate the recommendations for change. Not only has that not happened, they didn't seek any of those recommendations from the Caring Society, NAC, or regional experts. And you'll hear more about this today, but in fact, no experts on children and families were in the room when the final settlement agreement was negotiated. It was negotiated principally, as I understand it, between lawyers. We would never do that in any other negotiation. Finally, Canada was to provide funding for regional engagement on the draft compensation distribution protocol. That also hasn't been completed. So to the extent that AFN was chosen by the chiefs as being a representative body through which First Nations were going to be engaged, AFN has not complied with the fundamental requirements set out in the resolutions empowering it to be involved in the FSA negotiations. Okay, I want to turn briefly to the issue of funding and the serious potential for ongoing discrimination. And there's a lot being said about this right now, and the potential danger of a change in federal government from a liberal government to a conservative government, and what will happen if Pierre Poilievre gets elected. I want to be very clear from a legal perspective that the CHRT orders are in place and will remain in place. And experts have estimated that those will require Canada to pay approximately $45 billion over 10 years, probably even higher than that. If I leave you with one message today, I'd like you to understand that that funding is not at risk if the final settlement agreement is rejected and sent back for revisions. The CHRT orders will remain in place. The CHRT will retain jurisdiction and, most importantly, the ability to continue to force Canada to comply with its orders. And so that really provides the lens, in my respectful view, through which we should be evaluating the final settlement agreement. It should provide guaranteed funding that meets or exceeds what Canada is currently required to pay under the CHRT orders, and there should be binding mechanisms to require it to do so. And I'll get into this in a second, but those really aren't there. And this is very disconcerting because funding experts have reviewed the final settlement agreement and have concluded that the funding provided therein may be inadequate. And this is particularly true in British Columbia, where we only recently started getting prevention costs in the last few years. Now, you'll hear people talking about the dispute resolution process. It's insufficient to deal with funding shortfalls. And I want to be very clear about it. It does not have the jurisdiction to order Canada to fund new components that aren't addressed in the FSA, to increase funding for existing ones if the funding is inadequate, amend the FSA, or make any systemic changes. It would be not advisable to try and end the tribunal's jurisdiction in order to replace it with this dispute resolution tribunal that's set out in the FSA. Even more disconcerting is all of the funding that's set out in the FSA remains subject to annual appropriations by Parliament or other approval processes which aren't defined that are required by Canada. And as I mentioned a moment ago, because of the lack of a proper dispute resolution mechanism, the final settlement agreement does not provide a remedy to address any of this uncertainty. That's only in the first 10-year period. The term of the final settlement agreement is for 10 years. We do not know, and the FSA does not require Canada to provide any funding after the FSA expires in 10 years, meaning we could be in the same situation that we were in 2006, which required the monumental effort that the Caring Society has undertaken to prosecute this matter before the Canadian Human Rights Tribunal. As well, the FSA does not require Canada to provide any additional funding to First Nations, regional or sub-regional organizations beyond what it's set out in the FSA. So this is important. This slide speaks to BC, but it applies to all organizations outside of Ontario. There is no funding for regional or sub-regional organizations other than AFN, COO, and NAN, which by contrast are provided upwards of $100 million in the final settlement agreement. So no additional funding in Saskatchewan, Manitoba, Alberta, British Columbia, Maritimes, Yukon, and elsewhere across Canada. Perhaps even more disconcerting is there's no decision-making role. Again, this slide speaks to BC, but for anyone really outside of AFN, KU, and NAN. The only parties to the FSA are Canada, AFN, KU, and NAN. And the only formal decision-making that's set out in there, there's a couple of entities that would be created. The first one is a national secretariat. The membership of that secretariat is surprisingly limited to AFN, KU, and NAN. The Reform Implementation Committee, which is a central body that's created under the FSA to carry out implementation. Those members are appointed by Canada, AFN, KU, and NAN. And I really want to emphasize this point, and I can't understand why this would be the case. The committee members are required to carry out their work in a confidential process. Not only is the committee not required to consult with First Nations, but the committee members would be prevented from sharing that quote-unquote confidential information with First Nations in implementing the FSA. AFN is also responsible for selecting, retaining, and overseeing the program assessment organization. So that's the entity that's responsible for doing a 5 and a 10-year evaluation and determining if there are gaps in the FSA. Because nobody outside of AFN, KU, and NAN are parties, folks wouldn't be able to initiate what's called a parties dispute, which is a dispute in connection with the FSA or decision by Canada as to whether and how any recommendations from the committee will be implemented, or to seek leave to participate in a parties dispute or a claimants dispute. And those are claimants or disputes are situations brought by individual First Nations or their service providers to deal with the lack of funding. So as I mentioned, any information, quote, provided, created, or obtained in the course of implementing the FSA must be kept confidential, which means that it's not going to be shared with non-parties to the FSA. I'll make one or two more quick points and then end. Incredibly, the FSA actually provides ISK with additional powers, and ISK continues to be, despite being found as the discriminator, the central body that's responsible for providing the funds. So unfortunately, the reform put forward by the FSA, in my opinion, continues to rely on a colonial approach to the delivery of child and family services. ISK will continue to administer program and deliver the funds, rather than a different alternative, which would be to create an independent First Nations Treasury Board and First Nations organizations that could administer and deliver the FN CFS funding to First Nations and service providers. So I've already covered that. One quick point here. Despite the move by many First Nations to stand up their own child and family services laws under C92, self-government agreements, and treaties, there's really only 2 sections in the entire FSA that deals with this, and really it remains very unclear as to how the funding is going to flow to nations that undertake that work. So looking ahead at what's next, there are really, I think, 2 options here. If First Nations leadership approves the FSA, then the parties would bring a motion to end the tribunal's jurisdiction and replace the CHRT orders with the FSA. Given the fundamental flaws that we've identified in relation to the FSA, it would be important for regional organizations, First Nations, and delegated agencies to apply the tribunal for interested party status so that you would be able to participate in that hearing and share your concerns with the FSA about its fundamental deficiencies. This is by far the preferred option would be for leadership to reject the FSA. I want to emphasize that this has already happened in relation to the FSA for compensation. It was rejected, it was sent back for renegotiation, and then significantly improved. From my respectful viewpoint, that's absolutely what's required here. So Stephanie, I'll end it there and happy to take questions during the question period. Thank you.
Thanks so much for that, Scott. That was a great overview, and appreciate the very direct messaging. So we are now going to turn it over to Sarah Clarke. She's going to provide some key considerations and oversight of the FSA. So Sarah, over to you.
Thank you so much, Stephanie. Good morning or good afternoon to everyone, depending on where you are in the country. My name is Sarah Clarke, and I am honored to be one of the members of the legal team for the First Nations Child and Family Caring Society. So I'm joining you today from Toronto, which is the home to many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewas, and the Wendat. I also, in addition to working with the Caring Society, also have the pleasure of representing many different First Nations across Ontario in the work that they do to protect their children within the child welfare system. And so I want to also recognize that work today. In a very similar way to Scott's legal disclaimer, feel free to rely on Scott's slide number 3 for my similar legal disclaimer. I'm hoping to provide you today with some information, but not necessarily legal advice. I think it's absolutely the case that every First Nation and every agency that is going to be impacted by this agreement really reaches out to get some independent advice about how the agreement may or may not impact you and the children and youth in your community. So I have a bit of a PowerPoint slide presentation here. It's not as good as Scott's, but what are you going to do? It's just not my strength. So I'm going to take you through some of the agreement today. Stephanie, can you see my screen? Okay, amazing. Okay, so I just wanted to provide some additional context to what Scott has talked about, because I think I agree with everything that he has explained about some of the concerns around the agreement, but I really want to situate it within the context of the Human Rights Tribunal, because this really is an opportunity unlike anything else we've really seen in the history of a Canadian human rights complaint. So very often when you have a final settlement agreement like this, it's because the parties need to negotiate and compromise. Either litigation has begun or there is the threat of litigation on the horizon. And in order to protect yourself and those around you from impending litigation, you build a compromise to save yourself from having to litigate. But this is really a very different situation. The complaint, as both Mary and Scott mentioned, was started in 2007. And we got a very strong, probably the strongest decision in Canadian history on the rights of children in 2016. So COO, NAN, the Human Rights Commission, the Assembly of First Nations, and of course the Caring Society are coming at long-term reform from a place of strength. And that's not always the case when you compromise and negotiate a final settlement agreement. So I want to make sure that when we're thinking about how we're going to move forward and what you're ultimately going to decide within your own community, that you understand that you're coming from a place of strength. The Canadian Human Rights Tribunal has found that Canada not only discriminated against First Nations children in the provision of child welfare services, but that it is continuing to discriminate against First Nations children. It has not made a finding that Canada has completely stopped its discrimination. And I would say that because of those findings of the tribunal, the First Nations parties, the Caring Society, and ultimately the children who are really at the center of this work, they are coming from a position of strength. And that is very historic. We have not really ever seen anything like that before. So no one should be afraid to ask for what you need for your children and your community. So hopefully this is going to work. We'll see here. So what are we trying to fix in the child welfare system? The complaint has a lot of different aspects to it. It talks about child and family services, of course, and also Jordan's principle. And so as Mary set out earlier, we're really not going to be talking too much today about Jordan's principle. The final settlement agreement is focused solely on child and family services. And so that's what I'm going to be talking quite a bit about today. So the Human Rights Tribunal made a lot of different findings when it came to what Canada was doing in the provision of child and family services. And for those of you who have been following this case from the beginning, you'll remember that Canada tried to get out of the complaint at every turn that they could legally. Every procedural ace up their sleeve that they could pull out, they used to delay and derail the complaint. So that's one of the reasons why it took so long to get to the position that we're in. And one of the things that they really argued, and I remember I was actually in law school when the human rights complaint started, and I tell this story about how I was kind of upset that Cindy had started the complaint without me, because I had been a social work student at the Caring Society, and I thought, man, I'm just starting my legal career. I really want to work on this case, but it's of course going to be over way before I finished law school. Because the evidence about the discrimination had been well documented and had been in the public domain for quite some time. So I was kind of upset that they had started without me. But in any event, what we found in those years before we actually got to the substance of the complaint is that Canada actually tried to argue that they were not providing any services, that they were not a service provider under the Canadian Human Rights Act. And that was ultimately rejected after a finding of the tribunal, and we had to go back to federal court and ultimately to the Federal Court of Appeal. And the way that they control service and the way that they control how agencies can ultimately deliver what they need is by controlling where money goes and how it is spent. So under Directive 20-1, which was in place in British Columbia, and under the EPFA, which was in other parts of the country, maintenance was covered 100 cents on the dollar. So what that means is if a child was brought into the child welfare system, either into a foster home or into a group home, the federal government would give 100 cents on the dollar to the agency to provide that out-of-home support. But they were really providing, particularly in British Columbia, $0 for prevention, and in other places, negligible amounts for prevention, so that social workers could not on the ground provide preventative services to families. They could not offer supports in the home. They could not send parents to treatment. They could not provide parenting courses. They could not provide respite care in the home. They could provide almost nothing to families to actually mitigate a protection concern. And so what the tribunal found in 2016, based on the evidence, is what you see here on the screen, which was that by covering maintenance expenses at cost and providing insufficient fixed budgets for prevention, the federal government's funding formula provided an incentive to remove children from their homes as a first resort rather than as a last resort. And that, for me, is one of the things that I'm very concerned about, the structure of the funding that we see in the FSA. So prevention, as the Human Rights Tribunal has found, is a critical component to the delivery of child welfare. So child welfare is delivered on a continuum. We know that some children do need to come into the system because of the incredible risk that they may face in the home or have experienced in the home. But for other families, really what folks are dealing with are things around poverty, the structural drivers of child welfare, things like intergenerational trauma, the impacts of residential schools, and how that trauma mitigates itself and brings forward itself as a prevention, or pardon me, as a risk to children. And so prevention and sound child welfare practices, and particularly culturally relevant child welfare practices, are absolutely critical to A, keeping children safe, and B, keeping children in the home if and whenever possible. And so the Human Rights Tribunal in 2018 recognized that Canada needed to do more in delivering prevention services. It is a service provider under the Canadian Human Rights Act. So it has a responsibility as a service provider to make sure that services are provided in a non-discriminatory way. And so in 2018, you can see here that the Human Rights Tribunal actually said that services must be prevention oriented rather than removal oriented. And so in 2018, this was really the birth of what everyone calls the Actuals Order. The Human Rights Tribunal ordered that Canada has to fund least disruptive and prevention services at their actual cost, as well as things like building repairs, intake and investigations, legal fees, child service purchase amounts, and certain specific kinds of funding for small agencies. So First Nations agencies in 2018 had the ability to determine for themselves what their children and families needed, and then they can seek reimbursement from the federal government. Also in 2018, in Ontario, we had an order that allowed band representatives within Ontario to determine for themselves also what is in the actual needs of their communities. And that included things like seeking reimbursement for salaries, human resources, program delivery, the costs of helping families with transportation, and things like overhead and administrative costs, things that had never been funded before in Ontario for First Nation representative services were now available at the actual cost. So what we see in 2018, and I think sometimes, as those who are doing this work, we lose sight of how transformative the Canadian Human Rights Tribunal has been in this case. They have set out a structure of funding, principles of funding that are grounded in substantive equality and actually require the government to fund at a level that protects the rights of children. That's never been done before. And so that is really what they're calling on all of us to do in the development of long-term reform, and what this long-term final settlement agreement was supposed to be. We can do better, and I'm going to sort of try to highlight why that is. So keep in mind what I've said about prevention. It's absolutely critical to making sure that child and family services are delivered in a non-discriminatory way, that it's culturally relevant, and obviously operates within the best interest of the child, and that Canada was actually ordered to fund that at its actual cost. That did change in 2022 to try to bridge into a final long-term reform approach. But in my respectful submission, I know I'm not in court, but it's hard to not say that sometimes. It absolutely does not get us there. So the way that the funding for agencies is going to generally be structured is there's going to be a baseline of funding and to the agencies. And then there are a series of top-ups that will then be provided, things like IT, poverty, results, prevention, those kinds of things. And I know I'm jamming a lot into my 15 minutes, so I'm sorry if I'm being a bit overwhelming. But one of the things that is critical to understanding the baseline approach with the top-ups is that the research that was in the field for a number of years was very clear that in order for agencies to meet the threshold of providing non-discriminatory child welfare services, those agencies should get the baseline and all of the top-ups, including the prevention. That's not how it is set out in the FSA. In the draft FSA, as you can see here, ISC is actually going to allocate all of the prevention funding to First Nations. That means that First Nations will draw from their baseline to conduct least disruptive measures, which I would argue is not the same as prevention. It is something different. It's also important in order for them to meet their provincial requirements. So in every piece of child welfare legislation across the country, child welfare law requires agencies, whether they're a First Nations child well-being agency or a non-First Nations agency, to try to mitigate protection concerns in the home before you remove. So removal is supposed to be the last stop on the train. But that's not what the Draft FSA does. Instead, what it does is it places all of the prevention funding in the hands of the First Nation. Now, and it's similar in Ontario, it's a slightly different notice provision, but ultimately in Ontario, this is the similar approach. So why do I say that this is a problem? Why shouldn't First Nations get prevention funding? So that's not what I'm saying, but we have to think about the structure and how to entrench structure from a service delivery perspective. So first of all, the Draft FSA completely ignores the new federal child welfare legislation. There isn't even mention of it with respect to prevention, which I find very surprising. And it's not, when I say new, it's actually not that new. It's been in place since 2020. And so the federal child welfare legislation called an Act Respecting First Nations, Inuit and Métis Child and Family Services. It's a very long title. Everyone just calls it the federal legislation, or C-92, as you may recall. It actually entrenches for every jurisdiction across the country the priority of preventative care. So in different places across the country, there is a different kind of emphasis on the delivery of prevention services. Some jurisdictions like Ontario have a very strong approach to prevention. In other places like Alberta, for example, there is less of an emphasis on prevention. But we now have a national standard for all First Nations children across the country. Those kids are entitled to prevention as a priority. And so that means, in my view, that Canada has a legal obligation to fund agencies to meet their statutory requirements. That is a huge concern. I think this is a massive gap that agencies may be in a position that they were back in 2007 when this complaint was filed, to be unable, as a result of Canada's decision making, to actually provide prevention services to the legislated standard as set out in C-92. Now, this raises other questions about the approach here. I have a few questions. I picked 3 because it seemed like a good magic number, but I have like 27, but I only have 15 minutes. So my first question would be, why is Canada shifting the responsibility of delivering prevention to First Nations? I think there is some danger around this zone about, and I say this not so much as legal counsel for the Caring Society, more as an observation in the work that I do with First Nations across Ontario, is about actually allowing First Nations to decide for themselves if and when they're ready, they want to take on prevention. And they don't need the Draft FSA to tell them when they can do that. They can do that through their inherent jurisdiction as sovereign nations. They don't need the government to tell them how to spend money. So I think there's a question around downloading responsibility away from the federal government directly onto First Nations, and I have some concerns about that. It also raises the question about whether or not First Nations have been properly consulted regarding their own capacity to deliver prevention, and also liability. So one of the important things to remember is that under most child welfare legislation across the country, the agencies and the workers that work there are protected from individual liability as a means of law. So in most pieces of child welfare legislation, there's a section in the Act that actually protects individual workers from liability if something bad happens in relation to the work that they do. That liability does not extend to First Nations if they choose to deliver prevention. So there needs to be very good strategic planning around the delivery of prevention. And some First Nations are already doing this, but to take this kind of blanket approach, I think asks a lot of questions. And then, this question really came to me the last time I was with you as Our Children Our Way, when one of the elders opened up and talked about the crisis that some First Nations are in, and which begs the question is it really fair to ask a First Nation to divert federal dollars to an agency away from its own community when some of those First Nations are in crisis? So this is a very big concern. You're actually asking the First Nation to now have to choose between addressing immediate crises within their own community, which many First Nations do have, and then diverting that money to an agency. That in my, again, respectful submission, is absolutely not a compromise that should have been made here. This, coming from a position of strength, in my view, this could have been a yes and. There absolutely could have been an approach taken here where First Nations were absolutely given funding to develop and expand their own prevention programs, their own prevention approaches, and ensuring that First Nations agencies could also meet their statutory obligations under C-92. There absolutely was no reason, in my view, that this compromise had to be made. Okay, so I'm going to turn now to thinking a little bit about First Nation representative services. And this is where I would, if you're outside of Ontario, pay attention. And if you're inside Ontario, pay attention, because there's a very different approach taken under the FSA to the way that First Nations will be funded to support their children if they come into contact with the child welfare system. And as I mentioned, in Ontario, we've had the actuals order since 2018, and that has allowed First Nations to some extent to seek and receive funding to deliver, in Ontario we call band rep services at the actual cost. And so what, well, let me take a step back from there. First of all, I do want to say, and I want to acknowledge that on paper, the actuals order looks really awesome. But if you are a band rep in Ontario, you know that you are not sitting around your office dreaming up ways to access the actuals order. Most band reps that we work with are moving from crisis to crisis. And in between those deep breaths that they've been able to take, there have been some First Nations that have done or have had an ability to access the actuals order. That's not true for all First Nations. I can tell you, just as a practitioner, we have definitely seen over the last 12 or 18 months, a number of First Nations come and work with us who have never accessed the actuals order. And why I say that is because now for First Nations in Ontario, your baseline budget will be based on what you spent between 2019 and 2023. So for those First Nations, for those bigger First Nations that had some capacity and some infrastructure and frankly an ability to fill out an Excel spreadsheet, you may have accessed some actuals funding for your First Nation Representative Services program, which will give you some kind of a baseline to access, or some kind of a baseline to have a budget going forward. For those First Nations that were unable to do that, you're only going to get $75,000, which I think is a ridiculous number, and I would love to know how they came up with $75,000. As someone who does this day in and day out, $75,000 is not enough to hire, support, train, and develop even one band rep within a community. It's absolutely not enough. So that's a question for Ontario. And of course, the other issue in Ontario is that we've been told at other meetings that this funding is not going to support the delivery of band rep services for off-reserve members. As someone who's done ISK claims, I can tell you that we were never asked to separate on and off reserve expenses until very recently by Indigenous Services Canada. And I've looked at the orders on multiple occasions, and I'm not convinced that band rep was only for on-reserve members. The legislation does not make any distinction, nor does any child welfare legislation that I've looked at, including in British Columbia, make any distinction between serving on and off-reserve members. That's a distinction that Canada is making, and I think it comes dangerously close to triggering Jordan's principle in a very discriminatory way. So that's about Ontario. So even though some Ontario First Nations are going to start from a position of a budget based on what they've spent over the last couple of years, that's not the case in the rest of the country. So in the rest of the country, you are going to receive a budget based on your on-reserve population. This is a very convoluted and complicated paragraph, but essentially what this says is if you're a First Nation outside of Ontario, you're going to get $294 times the number of on-reserve folks that you have in your community. And if you're a smaller First Nation, your minimum will be $75,000. And then moving forward, it will get adjusted for inflation and population growth. So I think this really begs the question as to why the parties are agreeing to this kind of a distinction between Ontario and the rest of the country. It's been explained to me that the reason for this is that in Ontario, First Nations are really involved in their child welfare files, whereas in the rest of the country, that's not the case. So first, I would say that that's not my experience. It's true that Ontario First Nations, many of them are directly engaged in the delivery of support to their kids and families when they're in contact with child welfare, as have we seen in other parts of the country. And in most provincial legislation, there is some allowance, or I don't want to maybe put it that way, but well, it is kind of the way that it's put. There is some open doors for First Nations to participate directly in both open files through a child protection agency and through the court process. And that's certainly true in British Columbia. In British Columbia, we have Section 3, and then which makes it very clear that First Nations should not only be contacted, but they should actually be participating in the development and planning of services for children and families who are engaged in the system. So there is already statutory support for First Nations in British Columbia and in Alberta, for example, and actually across the country, to be engaged in child welfare at the front end and throughout the life of an open file. So I think that begs the question of could we, or why don't we, take a more of a yes and approach for First Nations outside of Ontario and allow those First Nations to also build up their baseline so that when they receive funding, they can actually make a difference. To me, that is what the measure is here. The measure is not, is this a compromise that we can live with? I think that's an approach you might take in a pre-litigation state, not in a post-litigation slam dunk. We have been able to hold Canada accountable all the way along position for First Nations. I just think that in the vision of a different way of thinking, in the vein of thinking about what's possible, transformative equality, there's absolutely no reason that we should be giving up on ensuring that First Nations can be funded properly to be directly engaged in supporting their kids and families when they come into contact with the child welfare system. So I think that that's a really huge missed opportunity. And the other thing I will say, of course, is that it also completely ignores C92. So C92 has very specific consultation provisions where the agencies must consult with the Indigenous governing body, and that those Indigenous governing bodies can and should participate in any proceedings. So, not to be freaky about it, but to suggest that $75,000 is enough to support a First Nation, to support First Nation representative services in a child protection piece of litigation, I would say is completely unfair. If anybody has ever been to trial on a child protection proceeding, you know that it can take weeks of trial time, expert evidence, preparation time, and you ought to be funded properly to have legal counsel represent you in the best way possible. And that's what Ontario First Nations have had up until now. And in my view, every First Nation should have that opportunity. You should not be using your own source revenue to engage in child welfare proceedings. And you don't need to. You're coming from a position of strength, and you should be asking for whatever you think you need. So in my final moments here, I just want to just point out some questions around accountability that I think are really problematic in terms of the timing. So I completely agree with everything that Scott has said about the approach, the lack of consultation. I absolutely agree that this looks like this is a take it or leave it draft. This is not a let's all engage in a consultation and engagement process. Let's cooperate. Let's have working groups. Let's have sharing of ideas and changes and come back together and see how we think this is going to roll out, where we have experts cost out and think about different ways of approaching these problems. That's not happening, and it's certainly not happening out in the open. And that is, as someone who's been working on this file since 2008, when I was a summer student, I can tell you that you should not give up. You absolutely are entitled to a completely reformed program, a completely reformed structure. And that's what the Human Rights Tribunal has asked us to do. This tribunal is imaginative, they're creative, and they make their decisions based on impact on children, not on what's best for the government or what's quickest or what's efficient. So anytime you're looking at this agreement, even where you're disagreeing with me on outcome, as long as you're measuring that against impact on children, then that's the way that the agreement needs to be read, not on what's easiest for government. So a couple of questions to leave you with and consideration. So first of all, I completely agree with everything that Scott said about the dispute resolution process. And keep in mind that it actually has less power to hold Canada accountable than what the Human Rights Tribunal can give us. So one of my basic questions is, why would you trade in a DR process for something that is less effective than what we have access to now? I can absolutely see why it might make sense to develop and build a dispute resolution process that is a bit more efficient, First Nations led, First Nations driven, First Nations informed approach to looking at protecting the rights of First Nations children within the Child and Family Services system. Absolutely. And there are some great examples out there that have done similar things where we can learn from. Why would you trade that in for this? This dispute resolution process, as Scott said, cannot change the agreement, cannot increase funding, cannot protect agencies or First Nations if they're not able to deliver service at the level that they need to deliver it at. So, I mean, it just seems to me a bit silly to do that. So if they took that out, I think that would be good. There's also a huge concern, and this is set out in paragraph 384 of the draft FSA, that if Parliament chooses to not appropriate the money, then the parties will have to go back to court in order to ask to reopen the human rights complaint. I don't still really understand why we would need an additional step there, why we would need permission from a court of competent jurisdiction, as it's set, to go back to the Human Rights Tribunal. There are ways, in my view, to entrench the structure of the funding without attaching a dollar figure to it. I agree with Scott. The existing orders we know are giving us $45 billion, if not more, if everyone had access to the actuals order. So why we would not entrench the actual structure into a final order to protect the structure, does not make sense to me. The Human Rights Tribunal cannot order Canada to spend $48 billion. Like, they can't write that down. That's true. But they can order a structure that will protect your children and families in a way that will prevent discrimination from recurring and ultimately deliver service in a meaningful way. As you also heard from Scott, the agreement's not complete, and we're still waiting for a whole bunch of these things. The other thing I just want to put out there that I want to make sure people have on their radar is about the timing of this agreement. So in June of 2024, the federal court approved the claims process for the removed child class. So children who were removed from their home families and communities between 1991 and 2022 will be able to apply for and start receiving their compensation in probably early 2025. So what you're going to have is a massive influx of money into community at the same time that agencies and First Nations are going to be trying to transition into this new system. And I would just caution, a pause anyway, to just think a little bit about that. We still don't really know what the supports are going to be to support those claimants through the process. We haven't seen any public information on exactly what those supports are going to be, other than the fact that we know they're going to be existing supports. And so I think it's going to be really difficult for agencies in particular to react to that influx of funding. And we know here in Ontario, there's some very interesting research going on that actually demonstrates that when the IRS became available in 2008, the rate of children coming into care goes, like, there's a graph and it just goes up like this. So agencies are going to have their work cut out for them when this big chunk of money comes into the system. And query whether or not also asking them to transition into an entirely new funding structure without prevention dollars is really the best timing for a massive shift like this. So I'll just put that out there. I really can't, being at the tribunal last week actually reminded me how, just how amazing really the entrenchment of children's human rights are within the Canadian Human Rights Tribunal. And we really have an opportunity to get this right. It's amazing to think that we would compromise at this juncture. We know that we can do better. And kids like Devin Freeman, who was from Georgina Island in Ontario, these kids deserve our absolute best, which I get emotional about because Devin was a really important part of Georgina Island and we lost him. And there's no reason to compromise now. You've won every decision that we've brought forward to the betterment of children. Jordan's principal has supported over 4 million products, services, and supports since 2017. So there is no reason to give up now or compromise. So I actually have to run. I'm not able to stay for questions because I got to go to court. But I really want to thank everyone for coming and listening and letting me go on a little bit. Sorry, I know I've gone over my time. And thank you, Stephanie and Cindy and Scott and Mary and everyone who's organizing today.
Thank you so much, Sarah. Thanks for being with us. So just a reminder, everyone, the presentation and all the material is going to be shared with you after we're done, so don't worry, and just encourage you guys to keep using the Q&A with your with any questions or comments that you have. So I'm now going to turn it over to Cindy to talk about Caring Society's vision of long-term reform and how we can improve on the FSA. So Cindy, over to you.
Well, thank you, Stephanie. And everyone, I'm going to be brief because I really want to give you an opportunity to have your questions answered. I just want to recognize Bert Crocker, who's on the webinar, and he suggested this great title. So shout out to Brett. And let's launch right into there as to how I think that we can kind of turn the corner and maximize benefits for kids. As I turn to my slides, I really just want to emphasize that the discrimination found by the tribunal was at the level of children. And so that means that we need to eradicate the discrimination at level of children. These conversations about who gets the money, in my view, is almost artificial. It really should be the individuals or groups or however the First Nation has organized it that can best meet the needs of children, particularly the children who are most at risk and in need of prevention. And when we talk about prevention, it's not necessarily voluntary. It's sometimes dealing with the most traumatized families. And as Sarah pointed out, one of the concerns I have is that the department has not been clear about what level of prevention needs to be provided, nor what happens while First Nations provide capacity. We support a yes stand vision, but we want to make sure everyone's set up for success. So here's my quick disclosure. We're a co-complainant in the ongoing proceedings. We were not a part of the negotiations. We left the agreement in principle because it included two key provisions. One is a confidentiality provision, which always makes me nervous when we're talking about other people's children, other nations' children. I really believe as a default in an accountable, open, and transparent process. The second was that you could not bring non-compliance orders against Canada. We brought a non-compliance order in December of 2023 against Canada. The parties insisted that the AIP remain in place. So to come back to the table, you had to agree to those same conditions for which we left. We felt they were insufficient to hold Canada accountable. We recommend that you consult with your own legal counsel. So let's get right to the chase. A couple of things that haven't been mentioned yet is that this agreement is already rolling out. It's no longer a 10-year agreement. Really, it started in 23-24, and so really there's only 9 years left. So that's a major thing to be aware of when you're talking about these different provisions. The clock is already ticking on our children. And, you know, there's a really no process I've seen for receiving or processing amendments, but we're going to introduce one for you for our amendments anyway, because the Caring Society, although we're not a party to the FSA, we are a party to the CHRT, and we do have authority under something called a consultation protocol ordered by the tribunal that Canada has a duty to consult us regarding solutions. And we feel very strongly that those solutions we put forward are better served by you. This is a quick comparison chart about what's in these, the status quo idea of what we have now versus what's proposed in the FSA. I'm not going to go through it in detail, but it's there for your reference. And please do, I always encourage people to fact check all of us. Make sure you go through the agreement itself. It's available on the AFN website in French and English. Here are some of the existing orders that were referenced before that are doing some of the backstops of the actual funding that's currently rolling out. So I'll start by just recognizing some of the strengths of the FSA, that it does include substantive equality as a principle. It includes something called a special purpose allotment, which protects against the department reallocating. And it also recognizes the importance of collecting data. We really agree with that. Where these things kind of fall apart for us is in the implementation of the agreement. We think there could be stronger measures to make sure these are actually realized at the level of kids and families and communities. As you're going to hear from the Caring Society, we feel there are themes of structural weaknesses throughout the agreement. And for that reason, we don't think just a patch up in one section is going to solve the problems. Here's just a synopsis of them. It's time limited. It has weak accountability for Canada that I feel goes below the current CHRT orders. It's inconsistent, as Scott has said, with Honor of the Crown and UNDRIP. There's no role for decision-making by First Nations post-approval. It's all held by this Reform Implementation Committee, which currently is proposed to operate in secret. There's a series of 6 other committees that are going to be governing this thing. This feels like to me like a bureaucratic mess. I think it could be much more streamlined. And there's political control over what are supposed to be apolitical secretariats. The funding structure is compromised. This alternative dispute resolution mechanism, as a First Nations person, I really would like to see First Nations courts, First Nations tribunals, but they have to be an improvement over the current system. And the current ADR is structured in such a manner that it won't hold Canada accountable for discrimination. My view is that if the ADR is not changed, I'd rather see the funds go to communities to deal with the opioid crisis that's driving so many kids in care. And it is supposed to be the replacement for the tribunal and all the tribunal's orders. Here are some of the big themes that we would like to see amendments on. In fact, because these problems are so structural in the agreement, we actually are considering whether rewriting the thing is going to be faster based on the evidence that we've already got from First Nations, the direction in those resolutions that Scott pointed out, and the input of our colleagues across the country who have done such great work as well as First Nations. I'm going to leave that theme for you. I'm going to just give you a couple of examples. So before I get to the examples, I'm going to talk about the structural weaknesses in the way that it was negotiated. One of the strengths and the reason this has been so successful is everything has been out in the light of day. We've always gone to leadership for direction on the big case. So when there's a big decision, we went to leadership, got direction. There was no secret kind of stuff happening. Technicians across the country were included, and they actually really seriously improved the progress of the work. So all of this stuff was done in a way that, in my view, was more about achieving an agreement versus really meeting that standard of ensuring that we're really honoring this generation of children and children to follow and safeguarding them and their nations from discrimination. So here's my process recommendation. So how do we make it different? That's the big question, right? You don't want to just be a backseat driver and concerned. So first of all, we want First Nations to retain their decision-making authority, and that includes First Nations not affiliated with AFN. And there are some out there, but this agreement will affect their kids, so they need to be a part of it. We want the resolutions fulfilled and regional expert participation and the National Advisory Committee to be real parts of it. That's part of that resolution. We want an open negotiation process. This isn't like nuclear secrets. This is about everybody's children from 633 very diverse and rich First Nations, and they ought to know what's going on with their children. Right now in the FSA governance, the government of Canada will know more about what's happening with First Nations children than First Nations leadership will, and that's unacceptable to the Caring Society. It's got to hold Canada accountable. I mean, that is the #1 reason for this. And so often there's outs for Canada in the agreement, and we feel those holes need to be plugged. I also don't think there should be any negotiation on a Jordan's Principle FSA until chiefs provide direction on a negotiation protocol mandate and team for AFN to make sure that this is done differently in the future. And there should be a clear amendment and rewriting process for the current FSA that complies with the direction already given by chiefs. If you're in a camp and you're thinking, well, let's just agree to it and fix it later, the problem is that you can't really fix it later in this agreement. First of all, First Nations can't amend it. Second of all, if you want a regional variation, then you're not going to be able to get that if it requires more funding from Canada. And that's all set out in paragraph 45. The Caring Society wants to not only wants to see regional variations, we want to see these things funded. And in fact, that's consistent with the tribunal's orders. It says distinct community circumstances matter and culturally appropriate services need to be offered. On the governance, again, this is the FSA governance thing that we kind of talked about. I'm not going to go through it in detail, but I will tell you that our fix is to have an open and transparent decision-making process with the chiefs making the major calls on big things. There's some discussion about this Reform Implementation Committee, which is kind of the chief committee in the whole thing, but it operates in secrecy and it makes all the decisions about reform, and it only issues a positive report that's agreed to by all the parties, including Canada. The only group sitting on there right now are COO, NAN, Canada, and AFN. The problem is even if you added more reps, they can't disclose anything, so that's not representation. It still supplants First Nations decision making, which is contrary to my view of UNDRIP, and also good practice for kids. And Canada, what is Canada doing on there? This whole object of this agreement is to make sure Canada stops its discrimination. It doesn't get a veto over anything. And we would rather see the funds for these other 6 committees really go to kids. We have a National Advisory Committee that's been going since 1997. It's volunteers. That thing can continue on. We have great regional experts that can be a part of this. And we want to just respect that there's an expert advisory committee that is independent and is meant to reform the department. So they should have an independent role because they're created by the tribunal. So let's take this whole bureaucracy and streamline it and maximize the money for kids and families at a community level. On the ADR, you've already heard about all the problems with it. What is our solution? Well, we want to fix this thing, as I said, or I want to just eliminate it if it's in the current form, because it can't do anything that's really important for First Nations, i.e. address systemic issues and ensure that Canada addresses discrimination if it recurs. So the Indian Act definition is also something we want to move away from. We've heard from First Nations and service providers that they want to deal with their kids on a recognition basis. The good news is that the department or the tribunals already recognize that in this order on Jordan's Principle. Why don't we use that and apply it to CFS? Because it recognizes the on and off reserve. And as Stephanie pointed out at the beginning, 72% of the kids in care are off reserve. So if we cut those kids out of this process, then we're really not getting at the major problem. So we are, I'm going to skip over the jurisdiction piece, other than to say that we want to recognize all forms of jurisdiction and make sure those are supported and there's no discrimination across it. We're working on these proposed amendments, but we need your help. And so everything we're going to be doing, we're going to publicly post. We've had some amendments. We had some input from regional experts. We are going to welcome your feedback on all of this. You can submit your comments online. We're going to have an online form. And in the remainder of my presentation, you're going to see a side-by-side of the existing text versus the proposed amendments we have. If you see something in there that's wrong, let us know, because this isn't about us being right. This is about doing right by your kids. And now is the time to really make sure that we land this thing for children. And frankly, if there's something in there that Canada won't agree to, then we take it to the tribunal and we litigate against them and get an order. This isn't like a bottom feeder thing where you just get whatever Canada agrees to. We don't have to do that. Our kids deserve much better than that. So I think I'm going to leave it there because I want your time for questions. And I also know that Mary has a few important words to say to you. Thank you, Stephanie.
Thanks so much, Cindy. That was great. Lots of hearts and thumbs up. So thanks for sharing. So we are going to turn it over to Mary to provide a regional perspective and hear from her. So over to you, Mary.
I'm going to be actually not giving the regional perspective. I think I've heard enough, but I'm going to have a few comments here. One of the things, I just want to read you something. Children hold a special place in Aboriginal cultures. They must be protected from harm. They bring a purity of vision to the world that can teach their elders. They carry within them the gifts that manifest themselves as they become teachers, mothers, hunters, counselors, artisans, and visionaries. They renew the strength of the family, clan, and village and make the elders young again with their joyful presence. Failure to care for these gifts bestowed on the family and to protect children from the betrayal of others is perhaps the greatest shame that can befall an Aboriginal family. It is a shame that countless Aboriginal families have experienced, some of them repeatedly over generations. This comes from RCAP, and this is in the CHRT ruling. This is what the tribunal included in their ruling. The panel goes on to say, this panel recognizes the shame and the pain and suffering experienced by children, families, and communities who were deprived of this vital right to live in their families and communities as a result of colonization, racism, and racial discrimination. This shame is not for you to bear. It is one for the entire nation of Canada to bear in the hope of rebuilding together and achieving reconciliation. That's one of the panels section that they've written over all of these different rulings. That is a panel that Canada and the AFM lawyers seek to get rid of. When we look at this case, what we are so used to in our communities and all of the work that we've been doing is that we're so used to Canada saying no. We're always, we never ever have Canada come to the table and say, hey, how can we make your life better? How can we make it better? And so we know that we are in this situation right now because of Canada's lack of adherence to ensure there was equality for our children. They had ample opportunities prior to 2007 when we launched the case. Many times they had the report, they had the research, they chose not to do it. So now we have this $47.8 billion first offer. It's a projection. If they said you have $47.8 billion right now, they gave us the money, could you imagine what we would do with the interest, millions of dollars an hour of interest? They don't have that. It's a projection. And so we have, Canada has, I've heard this in the last presentation a couple of weeks ago from an ADM, to trust Canada. They asked us to trust them. And I, for one, we can't trust Canada. The only time we've ever seen any significant change has been because the tribunal has ordered Canada to change. They haven't done this willingly. One of the things, we're so used to Canada saying no, but we should be expecting the best for our children. I think about it when they said, no, we're not going to change the funding. We're not going to increase it to ensure there's prevention monies for kids to stay with their children. The Caring Society, led by Cindy Blackstock, said this is unacceptable and we're not going to accept no. So here we are now in this situation. We have learned from the past experiences. So you look at Canada and the lawyers and the compensation. If you can learn anything, it's from the compensation, what just happened recently. Canada and the lawyers were fine with $5.2 billion as compensation. In fact, the very actors that are part of this final settlement agreement, the long-term final settlement agreement, thought that was fine. It wasn't good enough for us. So we said no. So what happened, we went from 5.2 billion, we went to $20 billion. And still that was not good enough. Canada was saying, this is all you're gonna get. There was fear mongering from the lawyers, as we know, and we still said no because it wasn't enough. So we ended up settling for 24.3 billion, an additional 4.3 billion. But you think about that from the initial 5 billion. So we're in this situation where this is the first offer. Just practically, this is the first offer. You know, in negotiations 101 that you never accept a first offer. We also know that there's many things missing. And I think when we think about the truth, that we need to make sure that everything is laid out, and we cannot be making negotiations or doing all this work in isolation and being in secret. Our chiefs need to know, our parents need to know, everybody needs to know what we are doing and what we're doing to remedy so that discrimination never happens again. When we think about, I just keep thinking about all the years that we've been doing this, and again, we're here at this place and time in history where we have to make the right decision and where we can't lose sight of where we're at. You've heard from Sarah Clarke, you've heard from Scott Smith, you've heard from Cindy, and all of these experts, and we've looked at it, and we have lived, breathed this ruling for over 18 years. We're not going to drop the ball at the 11th hour. And so the work that we need to do, I keep thinking about what the panel has said, you know, the shame is not for us to bear it, but it is one for the entire nation of Canada to bear in the hope of rebuilding together. Rebuilding together is operative. It's not about lawyers in isolation, in secret, saying what's best for our children without heeding the voices of the National Advisory Committee on Child and Family Service Long-Term Reform, without heeding the many voices of the youth, without heeding voices of the families that we serve. My last slide, if you look at my last slide, I think it's just, there are the regional, you're gonna have these presentations, but you don't know what you do not know. And I think that's really important, because what we don't know in British Columbia and the rest of the parts of the country is we really don't know what the cost of prevention is going to be when all the dust is settled. In British Columbia, we haven't received prevention money till about 2018, 2019, same as parts of the Maritimes and in the Yukon. We also, all the rest of the country as well, you don't know how much money is going to cost for prevention, because we just started receiving enough prevention at actual cost, and we receive prevention in different mechanisms to make sure that we're truly reflective of what it is to provide holistic child and family services. So we don't know what that is. We don't know what the potential of a national secretariat is. And the national secretariat is referenced in the agreement, but imagine this national secretariat that has functions that could, that can look at the innovative research, that can look at best practice, that could provide all the nations with the legal supports that they need to draft their own laws, to provide those small agencies and small nations with financial help, HR. There's so much that the national secretariat can do, but we don't know because we have not had the greatest minds come together. Just imagine for a moment, if we had those minds, those greatest minds coming together, imagine what this final settlement agreement would be. And I think that's what our children, not only today, but those not yet born, deserve. We can do better, and we have to do better. We have this one opportunity, this historical moment. And, we've been rushed. There has been, concerns about, the conservative government getting in. One thing we know for certain is that the funding is protected regardless of what government gets into place under the Canadian Human Rights Tribunal. And the Canadian Human Rights Tribunal that have written, if you read any of the orders and you see how eloquent they are, how they really get it, what we are trying to do, and they support us. So we would be remiss in our duties if we do not ensure that the Canadian Human Rights Tribunal oversee and maintain jurisdiction for at least 5 years of a final settlement agreement to ensure that Canada complies with what we're saying in our final settlement agreement. So I'm just going to leave it there, so there's time for questions. But I really want to thank you. Everybody's been wonderful, and I really look forward, and I know that we can rebuild together, and I know that we can do better, Masai.
Thanks so much, Mary. So thanks everyone for all your presentations. Now we're going to go through some of the questions that we've received in the Q&A. Some really, really great questions. So we'll just invite our panelists back and we'll dive right in. So the first question that we have is about the poverty funding and housing and household supports. So the question is about the formula of IFSD and why it only provides for 2%. And as a follow-up, it was also mentioned that the language changed from poverty to household supports. And so there's a question, how does this shift in language within the FSA release Canada from their responsibility to address First Nations poverty and or from being litigated against for not appropriately funding? So does anyone want to take that one on? Maybe mention the Spirit Bear plan?
Yeah, I'll take a quick shot at that one because we have a lot of good questions. I want to say to everyone too, we're going to keep track of your questions, and if we don't get to them online, we'll make sure that they get answered. I would recommend you look at the IFSD work at ifsd.ca. You'll find a full report there. That 2% actually is part of the agency funding. And it was very clear in the report when you read it that it's not intended to address the deep aspects of poverty that we see in so many First Nations. It's intended to only alleviate it within a child and family services perspective, and most often in child protection. So what am I talking about? I have a family, they have a child in care. I can't reunify that child until they have, housing of some kind of form. Maybe they need a first and last month's rent. So I'm going to pay that to get them set up so the child doesn't stay in care because the family can't afford rent. That is the kind of thing that it's meant for. In order to get at the depths of poverty that we're seeing in First Nations, there is a resolution from Chiefs in Assembly in 2017 called the Spirit Bear Plan, cost out all the areas of inequality, and there are a lot of them affecting kids, and then work with First Nations leadership to fix them. This program by program and drop by drop approach by Canada isn't working. And to quote the great Naomi Metallic, the human rights case is an example of what works, and perhaps future litigation on these other issues, including poverty and housing, need to be actively considered.
Thanks so much for that, Cindy. So next we have a question for Scott. And about guaranteed funding. And the question is if an agreement with Canada can ever provide guaranteed funding.
Yeah, so there's this thing called the Financial Administration Act that deals with that particular issue. That's in the context of agreements. I think what we need to see is a legislative solution to ongoing funding. And in fact, we started working on what that might look like, including some of the other sort of concepts that I mentioned earlier around a First Nations Treasury Board and other First Nations organizations that could receive statutory funding and then be responsible for administering that funding and getting it out to nations and agencies. So I think that's the better long-term solution rather than relying on the funding mechanism in the agreement. And I'll leave it there. Mary, Cindy, I'm not sure if you wanted to add anything to that question.
Yeah, we actually would really recommend 3 kind of tools in the tool chest to hold Canada accountable. One is statutory funding. Second is ensuring a very strong funding purpose, structure, and enforcement mechanisms in a legal order that can be enforced in a court or by the tribunal. And the third is showing results for your kids. That's why setting First Nations who want to deliver prevention up for success is really critical. Because right now, it looks like the government wants them to deliver services and build capacity at the same time, which is really difficult if you're trying to look for skilled workers and develop programs. Agencies weren't expected to do that. And we want to make sure that First Nations have the support so they can deliver those results. Those are some of the big protections.
Thanks for that, Cindy. So another question for Scott. Scott, you mentioned that the funding from existing CHRT orders is not at risk if the FSA is rejected. Is it at risk if Canada's judicial review of the CHRT orders is successful?
Cindy, do you want to speak to the status of the ongoing litigation?
Yeah, so for the current orders that I have listed in that piece, the appeal period is expired, or Canada appealed and was not successful. So it does not apply. It would only apply to a new order given by the tribunal, and Scott will correct me if I'm wrong, but I think whenever an order is made, any party has, I think, roughly 30 days to judicially review it.
That's correct, yes.
Great, thank you. So our next question for maybe Cindy or Mary, do we know why the FSA provides for all prevention funding to go to First Nations? What were the motivations or rationale behind this choice? And does the FSA allow for First Nations to redirect the prevention funding to their agency?
Cindy, did you want to go, or I can go first?
You go ahead, Mary.
Okay, I'll go first. So I think the at the end of the day, there has been a this manufactured issue between nations and agencies, and that we can really see coming at the negotiations table. Don't forget, we were at the negotiating table at the very beginning, and when we could no longer in good conscience sit there while Canada was not acting in good faith by not following the orders as per the Jordan Principle, that's why we were no longer at the table. What we have always proposed, and we are still proposing, is a yes and approach. It doesn't have to be that monies would go to the nations and the prevention, or the prevention money would go to the nations, and the rest of, as the final settlement agreement proposes, the tertiary or the intervention, the child protection would go to the agencies. This actually puts us in the same place as the reason we went to court in the first place in 2007. So what we're saying is yes, absolutely 100%. We can make a new final settlement agreement where the prevention goes to the nations as well as to the agencies, because you know the actual practicality. When there is a family at risk right now, we have the ability to say, okay, this family is at risk because there's issues of poverty. There, you know, the father needs a break to go to treatment. Whatever those issues are, we actually have the funding now to prevent children going into care. You can't separate it out. It's all child and family. So it's a yes and approach that we have been proposing, that we're going to keep on proposing. I think, and it really has to do with, I don't know what the negotiators or the lawyers' motivations were, but it definitely wasn't based on research. It definitely wasn't based on anything factual. And I have no idea what were in their minds, because I think at the end of the day, we want best for our children, all our children. So it has to be definitely a yes and approach. Cindy?
Yeah, and I'd say, like, we're really, you know, when I think about reform, I'm thinking about setting it up for self-government. And that means that this is a pathway to it. I think it's an artificial thing to say this is only a program and we'll deal with self-government later. That's not the way we do good governance. We want to build towards that vision. And in the case of First Nations across the country, leave it really flexible, because there's different models that'll work for different groups. So I want to respect that. I'm very, very concerned about the way this is structured. And the speed with which this change will happen. The Institute of Fiscal Studies and Democracies has said that First Nations agencies will be underfunded by $10 billion starting on April 1st, 2025. That is just a few months from now. And AFN's legal counsel said in a proceeding just recently I was at, that 2/3 of the money for child and family services now going to nations. Well, imagine what's going to happen at a nation level. What if I took any First Nations government and I said, I'm going to strip 2/3 of your funding, and you've now got to find a new service provider to provide all these programs for kids and families? It's going to be a huge disruption for the children, especially the most at-risk children, and especially for communities that are in the midst of an opioid crisis. To be clear, if there is a transition, the IFSD has said for the most developed nations and agencies, it's 2 to 5 years to be able to do that, not a few months. And that to me is irresponsible, and it's not in the best interest of children. And it doesn't set up First Nations for success.
I also think, Cindy, that the point of that actually, so what we know of is that we're actually in year 1 of that 10-year agreement. Nobody knew that. The chiefs did. We haven't even agreed or supported this, and Canada has already started implementing year 1 of a year 10. So we only have 9 years.
Yeah, that's right. And that goes by in a blink of an eye. That's less than half the time that we were really litigating this case.
Thanks so much for that, Mary and Cindy. So Cindy, this question is for you. Where is the Caring Society positioned in relation to the regional differences in the agreement, aside from the realities faced by BC?
Yeah, no, we want to make sure that, like I had the blessing of going to nations all over the country and visiting service providers. I've seen the differences in these regions. There's different legislation, there's different cultural realities, there's different distinct community circumstances. We want to allow for those adaptations. I've never envisioned this as being a one-size-fits-all approach. There should be a floor below which Canada cannot go, i.e. they can't discriminate against children and families. But above that, they actually need to have positive obligations to meet the distinct circumstances of the communities and also ensure culturally appropriate services. And that means that there should be allowances, not just for regional variations, but for in some cases, sub-regional variations, and in some cases, First Nations level variations. And those ought to be funded by Canada because that's meeting the basic orders as they currently exist. They have to provide the money for that. It can't be, oh, First Nation, everybody's got to follow the same approach. And that also speaks to the weaknesses of the amendment provisions of this agreement, that currently the only parties who can amend it are the parties themselves. And it has to be with full agreement, including by Canada. Well, if I'm Canada, I'm not going to agree to very much of these amendments. And, that's not setting kids up for success. That's a fox in the hen house governance system.
Thanks for that, Cindy. So we have a question about ISK's involvement. So if ISK is still involved in the implementation of the agreement, are they changing their reporting structures, policies for funding approvals? It is ISK who we blame for removing our children because of their systemic racism. This settlement needs an equal amount directed to making us the people we should have been, not what they made us.
Yeah, in my view, and I agree with Scott, and I'll welcome Scott and Mary to add on to this. This gives new powers to Canada. For example, First Nations have to submit a work plan for prevention. There's accountability there, and no one argues against accountability. It's a good thing when we're dealing with kids. There's got to be a work plan for agencies, and it's got to be 5 years. And if Canada on its own decides that the agency hasn't pulled its weight and achieved the work plan, it can use, I think, whatever measures are necessary to bring the agency into compliance. Sometimes you don't meet the work plan because the community's needs change, or there can be like a natural disaster that you need to respond to. So change, not meeting a work plan is not necessarily a bad thing. And to have the department be able to unilaterally go in and, in internal First Nations business, to me, is unacceptable. So I think there are new powers for the department, and they certainly have a lot of power in determining whether or not they are discriminating. And I can just personally tell you, I've been involved in this since 1997. Canada has only on one occasion admitted that it discriminated. And otherwise, it often says it is doing everything it can and it is not discriminating. So I have been asked by the minister why I don't trust them. I said it's because they don't ask and operate in trustworthy ways. They have to demonstrate they can be trustworthy. They're not there yet.
So maybe if I can just add to that, thanks, Cindy. Rather than the focus in the FSA being on Canada as the party that's been discriminating for all this time, the FSA, and Jessica pointed this out on the panel that we sat on a few weeks ago, actually flips that issue on its head, and it has Canada policing agencies on behalf of First Nations, which from my perspective is just entirely inappropriate. This agreement has to be founded upon stopping the ongoing discrimination by Canada, not agencies, not First Nations, and ensuring it never happens again. And it seems to me to be a little bit ironic that we're giving these new powers to ISK that was the source of the discrimination in the first place. And I'm hopeful that we can get to a point where we remove ISK from the situation altogether, have independent sources of funding, and those fundings are flowing to First Nations organizations, and like ISK just backs out of this field altogether. Mary, do you want to add anything on that point? No? Okay.
Great, thanks, Scott. Thanks, Cindy. So we have a question from Alan. They're saying, from what I'm learning from the presentation so far, this draft is reducing the funding available for services for children, but also limiting that funding for 10 years. Is that a correct understanding?
Yeah, like what we hear in the agreement is there's two funding reviews, one in preparation for year 5 and one at year 9. The problem is there's nothing binding to require Canada to actually operationalize those reviews. So after year 10, I don't read anything binding in the agreement to hold Canada accountable. And worse than that, the ADR is gone for as limited of protection that thing provides, and so is the tribunal. Scott, Mary, I don't know if you have anything to add.
Yeah, I think the easiest way to add to what you said, Cindy, is the term of the agreement is 10 years. After that, the agreement is done. There are no funding commitments after that. There's, of course, the review process that you mentioned that happens, just before the agreement expires, but there's nothing in the agreement that could require Canada to deliver on any of those recommendations. So from my perspective, there's a real danger here in terms of the second component, ensuring discrimination never happens again. There is no pathway to do that in the final settlement agreement, particularly after year 10.
I think the other point that we need to make is that we had established an expert advisory committee to actually change the ISK system, the federal government system, to change minds and hearts of the staff and to actually reform the system. There is nothing in that. So, we say there's nothing in year 10, but really there's nothing actually to that we can see that's really fundamentally changing the actual system that causes discrimination. And not to not heed the voices of an amazing expert advisory committee is just negligent on the parts of the negotiators in Canada.
Thanks, everyone. So we have quite a few comments about lack of involvement of frontline workers and those with boots on the ground. So just want to acknowledge those comments, and I'm sure you heard it was part of the various presentations that those voices were left out. So we have a question about if the FSA is rejected. So can you confirm that if the FSA is rejected, that all of the ISK funds will be still given to First Nations to continue their efforts in what has been done to date, and for how long these funds will be available?
And I would say that the current funding that's available under CHRT orders will continue. We're honestly not even sure how much of that money is actually locked in. As you know, that includes I think of it more of a 10-year projection with a 1-year reality, because every year Parliament can vote that amount down or up, or down, but there's not a lot of up in the agreement. So they have discretion to be able to vote it down. The tribunal orders have more durability, and that there currently isn't an expiry date unless they're replaced by another order. So I'd say one of the key things to find out for yourselves is how much money is actually coming to you. What does that look like for your region? How does that compare to other regions? And remember those missing pieces in the agreement. One of them is the terms and conditions in Appendix 10, and that tells you everything about how the money's flowing, who does it flow to, and how much you're going to get. And that's still missing and in the dark right now. So no one can say for sure actually how much is in that 47 billion, how much has been locked in, where it's going, and to whom, and for what purpose. It's all pretty vague. The only thing that you have is Appendix 1, and you'll see a bit of a flow chart there. But outside of Ontario, we understand that none of the First Nations or the agencies have received their allocations for next year.
Thanks for that, Cindy. Mary, I think this would be a great question for you. And it's from Hugh, and he's mentioning that many First Nations do not like the best interest of the child test. Some First Nations in BC have hereditary system of government or blended hereditary elected systems. Will proposed changes allow for these fundamentally different tests and approaches to childcare?
I think, of course it would be, because if you look at even in the agreement in principle, the way that we have in the preamble and some of the principles, one of the things that we made sure of is that in the principles that it was, holistic and it was needs-based and that it was based in culture. So it absolutely allows for the, when I say the yes and approach, right now we know there's such good practices in community where, the decision makers are the matriarchs, for example. That would still flow, that still needs to happen in community. So when we're talking about the yes and approach, there's a beautiful collaboration between the agencies and the nations to help them build capacity. Let's not forget that the agencies were developed at the really request and the fight from our leaders so that we could have an ability to make decisions and to build capacity in community. And that's why it's really important that we are reflective of what that culture of that nation is doing. So since even the tribunal talks about that, how prevention really is holistic, but really it takes into consideration the differences and the culture of that nation. And so absolutely a new revised FSA, FSA 2.0, if you will, what does take that into consideration.
Thanks so much for that, Mary. So we're just gonna try and get through as many questions as we can, and anything we can't get to, we'll follow up.
We have just a quick question for Scott because he has to leave. I noticed this, sorry for the interruption, but someone had asked it earlier. I want to make sure we get a good legal response on it. Some people have said that paragraph 379 about the approval. They've noted that in paragraph 380, it says that the agreement is not in force until it's approved by the tribunal. So does that mean that paragraph 379 is also not in force and the parties are not obliged to promote the agreement to get the endorsement of leadership?
Yeah, I think it's pretty clear for me that the parties are behaving in a way to promote the agreement and procure the approval of First Nation leadership, even if that section isn't yet in force in effect. The agreement that we have still hasn't been signed, right? I'm calling it an execution copy. So to come into legal force in effect, it'd have to be executed by the parties. But it seems clear to me that the parties are, and when I say the parties, I mean the proposed signatories to the FSA. So that's Canada, AFN, COO, and NAN are behaving in compliance with that paragraph 379. So hopefully that was a clear answer for you, Cindy.
Thank you. And I'd also just noted that all the legal counsel for each of those parties signed off on this agreement for approval. So as part of negotiations, they would, I think, have to oblige by that paragraph.
That's right.
Thanks for that, Scott. So we have a question on why is there a collective 226 million baked into the agreement for Canada to administer its own reform, including the work on cultural competency and other research?
Yeah, I don't think that stuff should be. It should be on top, and Canada shouldn't be dipping into children's money. That's just a general provision. There shouldn't be perks for Canada for having discriminated so egregiously against First Nations children, youth, and families. This is about relieving the discrimination from children, youth, and families and supporting the folks in First Nations communities who are right there with the families and trying to assist them, especially the most vulnerable. It's not about helping Canada.
Thanks, Cindy. So we have a question about if we know why there was a decision made to exclude technical experts from this process, and why was that done?
I think that's one to ask the parties. I'm thinking that maybe they thought it would be quicker to reach an agreement and easier to reach an agreement without them. My view has always been is actually, I think it's faster and better to do it with people. I know we have a lot of skilled folks across the country with different points of view, but I find when we work together, we actually not only get a better result, we get there quicker. And it's not like somebody goes into a room and then surprise, this is the deal we have for your kids. People have seen rolling drafts, they've been a part of it, their ideas are contributed. So at the end, the process in terms of the review, the fulfillment of UNDRIP, ensuring that agencies and other service providers, including First Nations, have a plan to be able to implement the agreement, all of that goes much smoother. So I'm in camp, let's do it out in the open and transparent and inclusive.
Great, thanks, Cindy. So I see we have Warner Adam has some questions. Don't know if I don't think you have permission, so you can probably just pop your questions in the chat. And we'll just do one last few questions, and then we will turn it over to Judy Wilson for our closing. And as we mentioned, any questions we didn't get to, they'll be available on the Caring Society's website, as well as our Children Our Way Society as well. And they're going to share out all the material and the recording with everyone. So a question is, we hear a lot about the change of government as fear tactics. What would the new Conservative government have at their disposal to stop or affect negotiations?
Well, they could just not negotiate, which is fine. Then we litigate against them at the tribunal to get any orders. Like, that's the thing, is that you don't have to just, like, negotiation often just works better for Canada in these scenarios. We've got the tribunal orders, we can go and get more. That's my view of it. Also my view, and I'd be interested in Mary and Scott's view, but I don't think the current agreement is going to be easily enforced. I think there's so many outs for Canada that it'd be difficult to hold them accountable. And their regime, as they set out in page, I think it's paragraph 384, to go to the federal court if there's a downward parliamentary appropriation. I don't think that's even something you can do under law. Because once a tribunal ceases jurisdiction, it can't be reopened by another court. You have to make a new complaint, and that complaint has to go to the commission. It has to go, then be investigated, then referred to the tribunal. That's my assessment of it, but I'm not a lawyer. But
no, I'm there as well, Cindy. I didn't understand that provision that would, you'd go to a court to seek to reopen the tribunal hearings. Once the tribunal's jurisdiction ends, it'll be what lawyers call functus, which is no longer seized of the matter and able to deal with it. So I did want to add to what you're saying, Cindy. So if there is a change in government and we move from a liberal to conservative government, the CHRT orders are going to remain in legal force and effect, and there's going to be an ability to continue to bring non-compliance motions. So if Poilievre were to win the election, the Conservatives take power, they decide that they didn't want to continue the negotiations if the FSA was rejected and sent back for renegotiations, we would still have those CHRT orders underlying everything and requiring Canada to make those payments that they're currently required to make. So for me, that's the backstop that we're talking about, and it's a pretty good backstop, if I can say it that way. And even better when you compare what's in the current final settlement agreement, which doesn't have an effective alternative dispute resolution mechanism to hold Canada's feet to the fire and prevent ongoing discrimination or discrimination from reoccurring in the future.
Yeah, thanks, Scott. I just want to make the one point that, again, don't forget that the reason we're at the negotiating table at the agreement in principle, the tribunal did talk about, the immediate measures, the long-term reform. However, when CHRT 41 happened, if you recall, it was on the eve of the first National Day of Reconciliation, and Canada was threatening, well, they were going to appeal. And so at the 11th hour, like, how would that have looked if Trudeau government was actually taking our kids back to court yet again? So really late in the day, Canada agreed that they would negotiate and the parties had to agree. So we agreed to negotiate in good faith. And so prior to that, don't forget, it was the CHRT orders that was giving us direction. So we had the prevention at actuals, we had all of these pieces, and plus we had won the CHRT 41 already. And so so Canada had agreed not to appeal, we negotiated. So moving forward, if there is a conservative government, absolutely, there is an ability to negotiate. We're going to maintain, we will negotiate in good faith. That's both parties though, that's Canada and us, and all parties at the table in good faith. And that's our bottom line. Like, we can't sit there and have Canada contravene the orders and not be acting honorably. And that's why we are no longer at the table, because we had to file an order of non-compliance on December 8th of last year to ensure that Canada was maintaining the orders as per Jordan's principle. So again, if the Poilievre government gets in, we still have the CHRT orders that exist. And if they so choose, then we keep negotiating in good faith.
Thanks so much for that, Mary. Well, I want to thank everyone. Thank you, Mary. Thank you, Scott. Thank you, Cindy. And thank you, Sarah. And thank you, everyone, for your very active and engaging questions. Anything we didn't get to, we'll make sure that we follow up, and it'll be shared on our website as well as with Our Children Our Way. And for everyone that signed up and registered, you'll receive an email from us. So again, I want to thank you and wishing you all the best. And I'm going to turn it over to Judy Wilson to close us out.
Cooksham, thank you. And I'll just say a closing prayer for that. Cooksham, Culpic, be creator, we thank you for the discussions and the truths and the forward-looking ways we can protect our children and serve our children and families in a good way, that we can do better, Creator. And we pray that this messages, what the presentations were about, and the input and the questions that were heard in these that they get raised to larger bodies of meetings where they can be deliberated in a good way, that we can find resolutions to these issues so that our children and their families are getting the utmost best that for the ending of the genocide, discrimination, and the harms that have been caused to our children and families, and that truly does have an ending, not a continuation, Creator. So we thank you for all those in the circle, any of those that are traveling. We pray for their safety and good keeping. And we also pray for the children and families that they come home in a good way, that we're able to take care of them in a good way and support them, and that they live their lives the best way possible. And we also thank you again, Creator, for our beautiful Mother Earth, who sustains us in so many ways, and the water and all of creation, Creator, that we're interconnected to the web of life, and we continue with our knowledge and our teachings, and that we can bring that into our families and our homes and our communities, and that we truly come together in a good way, Creator. So we thank you for this, Creator, and please take care of our presenters as well. They're doing all the hard work. We pray to uplift them and give them the continued support and the continued love to do this work. Just as we heard at the Loving Justice Conference, we can't accomplish this work without love, Creator.